Hi, welcome to another knowledge sharing series by Europe India Corporate Finance Forum by EBTC. And today we will talk about international arbitration and International Arbitration Center by IFSCA. And with us, we have a team of AZB and partners, Mr. Bahram Vakil, Ms. Saloni, and Ms. Anusha. Welcome to all of you here. So, sir, I would like to start with you. With the uptick in global trade, what is the role regulatory bodies are playing, and specifically government?
Yeah, thanks a lot. Thanks a lot, Vaishali. Thanks a lot to EBTC for this opportunity. Yes, I think India is very focused on its trade and its trade partners. So we've had a very healthy growth. In fact, the last numbers for merchandise exceeded the target was to do an export of over 400 billion. I think we crossed that. Of course, in the services, which is a big strength area for India, again, there's a very healthy growth, and I think the total number was around 675 billion. And the aim is to take that to 800 billion. The government is very incentivized to help exporters, to make it easy for importers, because there's no question that we need this trade. And in terms of the regulators, really, Vaishali, very straightforward. There's the Reserve Bank of India. Currency is not a free float, so there are some restrictions. But in terms of trade, it is completely open. What the RBI does is help exporters primarily to get good terms of credit. And we have, like most countries, export credit agencies which help exporters finance at a competitive rate. So RBI really plays only a productive role, and in terms of trade, as I said, there is very few restrictions. The other is the government itself. So the Director General of Free Trade. So you get the import in the name itself. The idea is to keep it as open as possible. But what I would say, to be honest, we have not achieved too many of these FTAs on a group basis. I think India has decided that it's easier to do this on a bilateral basis. We have a lot of FTAs country by country. The one that is most in the press at present is the one with UK, and we have several with major trading partners. There is definitely an attempt to increase this as we go along. With Europe, that's our third largest trading partner. Certainly, the idea is exactly the same. And another point, I mean, it's not directly related to trade in terms of payments as well, where India has a fantastic advantage. We do 7 billion digital transactions a month. And as a country, we consume more data than China and the US combined. So, I mean, that's quite amazing. This digital payments, again, while it's been domestic, we just signed up with Singapore a link so that you can have cross-border remittance at a fraction of the cost and within 5 or 6 seconds. Now we are also working with other neighboring countries, including UAE, etc. And I'm sure looking at doing this with EU and UK as well. Many thanks.
Thank you. Thank you, sir. So my next question is that how currently international disputes are handled, say between an Indian business and a European business?
Hi, Vaishali, I'll take that. Thank you to the EBTC and thank you, Vaishali, for having me. You know, the problem really, or really the benefit is that Indian courts are essentially much slower than, courts in Europe or courts in any part of the West. The trend today is obviously to be pro-arbitration. You can have, two kinds of arbitrations. You can have arbitrations that are seated in India, and you can also have arbitrations that are seated outside of India. If you are seated outside of India, then that of course means that your challenge to an award will also be outside of India. This is really the trend that happens today. So most companies which have disputes with companies in Europe, at the contracting stage, they always tend to seat their arbitration. In our experience, it's usually in Singapore or London. Even if it is European company, more often than not, because of the language constraints, we've seen that it happens in London or Singapore. That gives you some sense of direction and having a sort of impartial judge monitoring your systems. What I can say, though, is that contrary to what most people think, the Indian regime, the courts are very pro-enforcement. The last decade has actually seen almost all awards being enforced, both from the domestic side and the foreign-seated awards are enforced with the same amount of pro-arbitration regime that the courts are trying to sort of enforce. That also means that a lot of the promoters, Indian promoters, when they are contracting or negotiating dispute clauses, they're okay to have their disputes seated outside India because it's equally beneficial for Indian promoters today to have their disputes sort of resolved in a quick, efficient, and timely manner. The only time then that you will come to an Indian court is if you're looking to have interim release, or if you're looking for having assets seized for execution purposes. Once you get an award in your favor, and if you're looking at seizing assets, you probably want to come to an Indian court. In those instances, I think parties are now very smart. So what they always will do is at the contracting stage, they'll have a clause in place in the agreement that will require you to take your dispute or have your dispute resolved by a court in, say, Mumbai or Delhi. So you sort of have an idea about how these courts are going to deal with these matters. They also have the commercial expertise to deal with these matters. Another trend ordinarily today is that most contracts have a tiered dispute resolution mechanism. So you don't go into the dispute immediately. That's a cost-saving tactic. So you will try and have settlement that is usually done before you invoke. It's a required thing under the contract that you try and settle your disputes amicably. To the alternative dispute resolution mechanism in India, we also have a growing tendency to have mediation, conciliation. These are all new emerging areas, but slowly progressing, and you do have some amount of disputes getting resolved by mediation and conciliation. And I think lastly, one of the things that India is seeing is you have a lot of arbitration centers that have now started in India, right? You have the Mumbai Center for International Arbitration, you have the Delhi International Arbitration Center. All of that is hopefully going to lead to a situation where there are more arbitrations in the country, and essentially that will mean that there will be less burden on the courts, and hopefully in a decade or two, the courts will be as efficient as it is in any Western part of the world.
Thank you. Let's truly hope for that. And my last question is that we're already hearing about IFSCA setting up International Arbitration Center. So what is the role of IFSCA and how this International Arbitration Facility will bring a positive change?
Thank you, Vaishali, for having us. I'll give you a 2-minute overview on the IFSC. The IFSC is the International Financial Services Center in India. We have a maiden IFSC which has been set up in Gujarat. It is ideally positioned as a gateway for inbound and outbound requirements of international financial services in India. The objective is to attract offshore businesses to the IFSC to make it a robust global financial center in India. The IFSCA is a unified authority which is regulating financial products, services and institutions within the IFSC. In our budget speech for 22-23, our finance minister has acknowledged that a quick and cost-effective dispute resolution mechanism is one of the prerequisites for a successful financial center. Towards this end, our finance minister has announced that an international arbitration center will be set up in IFSC for timely settlement of disputes under international jurisprudence. Further to this, our IFSC authority has entered into an MOU with the Gujarat Maritime Authority and has set up an international arbitration center for arbitration of maritime disputes specifically. It's called the Gujarat International Maritime Arbitration Center. Our regulators have had the benefit of learnings from SIAC, which is the most preferred arbitral institution in Asia Pacific, and so many of the USPs that the SIAC has have been sought to be brought into the regime in India and brought into the infrastructure in India. For example, our aim is to have experienced, varied and international arbitrators. We already have a schedule of fees to bring about transparency in legal costs. The intent is to provide state-of-the-art administrative and technical support for hearings. There are provisions for appointment of an emergency arbitrator. Like all international arbitration centers, we have a model clause. This is currently been implemented for arbitration of maritime disputes. But circling back to what our finance minister has declared, the intent is to have a facility for international arbitration of all disputes, keeping in mind the overall objective of the IFSC.
Thank you. This was very helpful. I would like to thank all of you for giving your time and telling us so much about the new facility that is coming, and also about the international disputes, that how they are resolved and what is the way ahead, and how we can look at a brighter future where the disputes in India will be resolved timely. Thank you all.